Welcome to Legal Studies, and today we're going to be learning about the Doctrine of Precedent. And in particular, we're going to be focusing on how the Doctrine of Precedent can affect the ability of courts to make law. So in other words, we're thinking about how can precedent help or hinder courts when they're trying to make new laws. So in terms of this topic, we've already learned about what precedent is. We've learned about how judges can sometimes be a bit flexible by reversing or overruling or trying to distinguish the case in front of them or write a disapproving judgment. And now we're going to take those features and we're going to use them to think about, again, how does this help the courts when they're making law, and how does this hinder the courts when they're making law? Because, of course, every time the courts make a precedent, that's actually them making a law. Anytime they make a decision, courts in the future have to be consistent and make the same, types of decisions that this court has made. And so that creates a set of laws for courts in the future to follow. And so the ways in which this can assist or help courts to make law is, this ensures consistency. Right? Because we know that we follow precedents from the past. This creates consistency, which makes sure that the courts are helped to create law that's consistent and easy to follow. It also helps the courts making law in the sense that they know what the law is, so they know what the decisions have been in the past. They know what decisions they need to make now. That can help them in the lawmaking process. On the other hand, this can really hinder or limit the ability of courts to make law because of the nature of binding precedent. We know that if you've got a decision made in one of the courts above you, that's binding on you. You have to follow it, which means even if you think the law should be changed, even if you think you should make a different decision, you can't. So the judges in the lower courts are really quite limited in their ability to change the law or make a new law. Thinking again about some ways in which this can help courts make law, this system is pretty flexible. The system of precedent is pretty flexible because even if, as I've just said, you've got a judge in a lower court who's bound by precedent and has to make a decision they think is wrong, it can eventually be appealed up to the higher courts, and in those higher courts, the judges are able to overrule or reverse precedents. All right, so they do have the ability to change the law and make new law. We just have to appeal them to one of the higher courts first. On the other hand, in terms of how this can sometimes hinder the courts when they're making law, well, judges in those higher courts, even though they have the ability to change the law, sometimes they can be really reluctant to do that. And often this can happen, for example, when they think maybe Parliament would be in a better position to change the law. So, for example, we're going to learn about a particular case called the Trigwell case. Essentially, in that case, the court said, well, we're being asked to make a change to how the law of negligence operates. We're not really comfortable with that. We think negligence is such a huge area of law that if we were to just make a change on this one topic for this one case, it wouldn't be enough. We're going to wait for Parliament to make a big, broad change to the whole area. And that's what they did. They just waited and they made no change, even though they thought in that particular case that the precedent that they were following was wrong. So sometimes they can just be really reluctant to make a change because they think Parliament's better suited for big, broad-scale change. Other ways that the doctrine of precedent can help or hinder. Another factor that hinders the ability of courts to make law here is the fact that, well, yes, they're able to make law through creating new precedent, but only when a case is actually brought before them. They've got to be willing to wait for someone to bring a case, and people don't often do that because court cases take time and money and they're stressful and things like that. So that can really limit the ability of the courts to use precedent to create new law. Further, even when they do get a case in front of them, courts can really only make law sort of after the fact. It's a Latin term called ex post facto. It basically means after the fact. Courts can only make a decision once someone has already had a problem. because they have to wait for a case to come to them. And by the time a case has reached the court, someone's already in trouble or someone's already had a problem. And, sure, the courts can change the law at that stage, but maybe it's already too late for that person. And so Parliament is often in a better position to change the law before problems happen. On the other hand, courts and their ability to create precedent, particularly precedent that comes out of their interpretation of what different statutes mean, laws made by Parliament, they can play a real complementary role for Parliament. Parliament could put out a law about a particular topic, and if there's gaps in that law, then the court can step in and say, all right, well, this is what we think Parliament meant, or this is how we're going to fill in the gap that was left in that legislation. So they can play real complementary roles in the making of law. And that's it for how the doctrine of precedent can help or hinder courts when they're making law. See you next time.